Mr. Priest. We're ready.
Good morning. May it please the court, counsel. Your Honor, my name is Jamie Priest. I am here representing.
You have to talk up.
Yeah. I am here representing the Pollard family of Olive Branch, Mississippi. Isaac Pollard and his parents, Ronnie and Lisa Pollard. I am here today to ask the court to reverse the judgment.
You've improved some, but you're just going to have to be robust with it. These high ceilings just make it hard to really hear, so I know you don't want to feel like you're hollering, but maybe if you get a little bit closer to the mic and just talk into it. Plus, the other thing is we're recording, the arguments, and if your voice is too soft when we listen to the arguments, it's kind of hard to hear. So.
Yes, sir, Your Honor. I apologize.
No apology.
For my voice. I think it's hard to carry.
That's better.
Yes, Your Honor. As I was saying, we are asking the court to reverse the judgment of the Northern District of Mississippi in this Section 1983 case in which the plaintiffs alleged violations of their Fourth Amendment rights under Section 1983. The district court was able to find the sheriff deputy's defendants subject to qualified immunity only by resolving disputed issues of fact in their favor and in construing the factual scenarios in the favor of the defendants, which is impermissible under Rule 56 and the general principles of summary judgment adjudication. To briefly describe the claims, the Fourth Amendment claims involved are for illegal detention of Isaac Pollard, for an extension of that detention into a situation that resulted in the excessive force used against him, and also for the warrantless entry of the sheriff deputy defendants into the Pollard home. I'm sure your honors have read the facts as described in the brief, but to distill it down to the essence of what provoked this confrontation between the police and Isaac Pollard. Isaac Pollard went for a run in his neighborhood late at night, just for exercise. He was out for a run. He was stopped during his run by Officer Perkins, or Deputy Perkins, who inquired as to what he was doing. Well, I'm sorry, Your Honor, I've mixed that up. Isaac Pollard was out for a run. He felt that he had run a longer distance than he ever had, and he wanted to measure his run. So after he got back to his own house in his own neighborhood in which he had just completed his run, he got into his own vehicle and was going to drive around, measure the distance of his run with the odometer on his truck. While he was measuring his distance, he was pulled over by Deputy Perkins, inquiring as to what he was doing. Isaac told him, "I'm measuring my run." Deputy Perkins said, "Okay, go on your way."
Excuse me, would you repeat that?
Deputy Perkins, after he had stopped Isaac Pollard in his vehicle, was apparently satisfied with the explanation. He was measuring his run, and it released Isaac without any further, questions. Isaac returned to his home in his truck, went inside. Apparently, while not apparently, while Isaac was out on his run, one of his neighbors was sitting a married couple were sitting in their home, thought someone was outside in their driveway. According to their statement, 5 minutes later, the husband, Mr. Martin, went outside and saw someone matching Isaac's description on the street, not on his property, on the street. He was walking, and then he ran as Isaac was out for a run. Mrs. Martin examined the car, thought it had been rummaged through, and so they reported it to the sheriff's office.
You're going to use all your time on telling us the facts. I mean,
Yes.
you can do what you want, but we asked you to come prepared specifically for a couple of Supreme Court cases.
Yes, sir.
So I'm going to jump in. You can
Yes, sir. Yes, sir.
In your brief to us, are you disputing that there was an exigency and arguing that it was a created exigency even under King? Or have you preserved below and preserved by us there was no police safety exigency at all?
Well, Your Honor,
What's your argument as to exigency, which is what the district court focused on? Are you saying any exigency was created by the police, or have you disputed to us that there was an exigency at the outset?
Your Honor, my argument is any exigency was created by the police.
Okay, so you don't dispute that there was a police safety exigency in the first place?
Your Honor, I would dispute that if Officer Perkins had not, and again, this goes to a factual dispute, as alleged by my clients, if Officer Perkins had not instructed Isaac to go into his home, he would have not been out of sight of Officer Perkins. To not find that it was I think under King, to not find that that was a police-created exigency, the burden would have to be on Isaac to refuse to go inside per the instructions of Deputy Perkins.
But for King to say, let's talk on the back of your truck, you need the key, go get the key, how is that violative of the Fourth Amendment? Right, that's pretty much that's your allegation, right?
Yes, Your Honor. Yes, Your Honor. That in of itself would not violate the Fourth Amendment. Just asking him to go get the key.
But then escorting him in.
But when these two deputies stepped across the threshold of the home, followed without consent.
There was no denied consent. You're arguing there wasn't even implied consent?
Our argument is there was no consent. If the only implication of consent would be a lack of protest on Isaac's part. I think under the right.
Right. I mean, these police citizen encounters are frequent. Late at night, neighbors call, they show up. Let's imagine it's a domestic violence case. One of the occupants of the house is outside. And then they start talking to that male, let's say. And the male shivering, whatever, and they say, what's your problem? Oh, need a sweater, or I need my diabetic medicine. And they say, go in and get it. You're saying clearly established law is that the police can't escort the person in and then come back out and not seize anything. If so, what's your best case that that's violative of the Fourth Amendment?
Your Honor, I believe that the situation that you just described is distinguishable from this, because in that situation, the detainee initiated.
No, I'm imagining you hypothetically assume the police say, go get your medicine. They tell him to. Occupant doesn't say it. Go get the sweater. And then the guy says, okay, and walks, and the police think, well, we better escort him. We don't want him to grab a gun.
But how old is Isaacson? Or what's his name?
At the time of the incident, Your Honor, he was 23 years old, I believe.
23, but
Yes, sir. He lived with his parents, and he
was autistic.
He has autism, yes, sir.
He was clearly not the head of that household.
I'm sorry, Your
He
Honor.
was clearly not the head of the
No, sir.
household.
No, sir. No, sir.
And what about, are you relying at all on Peyton to be New York?
Your Honor, in response to Judge Higginson.
No, go ahead and answer Judge Dennis's question. Are you relying on Peyton?
Yes, sir.
Probably
Yes,
gonna have you-
yes, sir. Yeah, I'm relying on Peyton. I think Peyton is the clearest statement that the home is absent consent, absent a warrant, absent exigencies. It should be,
What should the
Reliable.
officer have done in this situation? Should he have just given, in other words, I understand the young man was going in to get his keys and his phone. Is that right?
Your Honor, it's disputed that he was going in to get his phone. The
Oh.
defendants allege that he
Okay,
had.
but even just keys, he was going in to get his keys.
Yes, sir.
Okay.
What should the officers do in that case? Are they required under Peyton to pause, give him a chance to get his things, or are they say they're afraid he's going to get a gun, so they go on in? It's more or less a manufactured
Yeah.
exigency.
Yes, Your Honor.
It's kind of like, and
I'm
also, is it similar to the no-knock situation where the officers can go up and knock on the door, but they can't just automatically go in. They have to give the homeowner a chance to answer the door.
Yes, sir. Yes, sir.
Here, I'm kind of on your side.
Yes, sir. I understand. And
It seems to me that Peyton and other cases require officers to be more respectful of the home in barging into somebody's house under the Fourth Amendment.
yes,
I
sir.
don't think it just protects against searches. It protects against intrusions.
Yes, Your Honor. I fully agree. And
What about the first question Judge Dennis asked you? What should a reasonable officer do?
Number one, there was no necessity for him to direct Isaac to go into the home. So he didn't have to let Isaac out of his sight. He had him detained. It was his choice to send him inside.
I thought the police are facing serious Fourth Amendment problems if they keep him detained, right, while they go get a warrant. I thought the Supreme Court repeatedly says the thing you should do is escort the person inside while you're seeking a warrant. Right? Isn't that the reasonable thing? They do him a courtesy. But get a sweater, get your medicine, get your keys. We're coming in now. We're not going to seize anything. How long were they in there, maximum?
1 to 2 minutes.
And you
It
agree?
was a brief.
You agree they didn't seize anything?
I agree, yes, Your Honor.
And did they have have you stipulated, or do you agree that they didn't have an intention to find evidence?
I don't agree, and there's no stipulation. They walked it through the door to look around. It would be our position on that.
You got a minute, that you were directed to Jones, probably direct specifically to footnote 5. Do you have any thoughts on that?
Your Honor, there was an invasion of the privacy of the Pollards, which would be, as I understand Jones, that's what that case considers a trespass.
Well, it's not just him. Aren't you representing his parents?
Yes, Your Honor, that's correct.
They're the owners of the house.
Yes, sir. All were home at the time. Your Honor, regarding whether as I said, I don't think it is undisputed that there wasn't a search, two officers
Right, but you've
walk
got
through the door.
clearly established that there was. It may, it may be very debatable. It's hard to harmonize Peyton with Jones, the footnote.
Yes.
Okay.
Yes, I agree, Your Honor.
Ask one question. What is your best case?
My best-
In the circumstance where an occupant is, yes,
Madam Clerk, Pam, give him 2 minutes, please. Okay, now we got more time.
my only question is going to be, what would be the best case you'd point at for this somewhat common police-citizen encounter where they escort someone out in a minute and don't find any evidence that clearly established law says that violates the Fourth Amendment? What's the case you point us to?
Your Honor, the best case that I can point to on that issue is Peyton. And I agree that the footnote in.
No, that's all right. That's fine. If that's your best case, that was my
Yeah,
question.
yes, Your Honor.
But you still have more time.
What case is the other side relying on? What cases is the government?
The government relies on the standard cases recognizing exigencies as a.
I thought they were relying on a footnote in the trespass case.
Your Honor.
They're not relying on that.
Your Honor,
Sorry.
I'm sorry. As I understand it, they just rely on the case.
We'll hear from the government in a minute, and we'll all be clear on what they're relying on, and then you'll get a chance to rebut it, so we can clarify. You got 40-something minutes left. I gave you extra time. So if there's something you didn't say because we interrupted you, go for it.
Well, Your Honor,
But you may have overlooked it because it's not a house case at all. Go ahead.
yes.
I'm sorry.
Yes, Your Honor. At this time, in the last 15 seconds, I don't have anything to add to that, to our discussion of this matter.
Okay, I just want to make sure you had full opportunity. All right.
Thank you, Your Honor.
We will hear from Mr. Allen.
May I proceed?
Yes, sir.
Thank you. And Jeff Allen here, Clarksville, Mississippi, on behalf of the appellees in this case. I'll jump right in, Your Honors. My take on this is threefold. Number one, this is not a search. There's not an allegation in the complaint that this was a search. Number two, if this were, so we go step by step, if this were found to be a search, although I believe that the definitions of a search from Jardines, Florida v. Jardines, 569 U.S. 2013.
Where in your brief to us did you claim with legal authority this wasn't a search?
Your Honor, I don't think there's an allegation.
Where in your brief did you defend this with legal authority saying this wasn't a search?
I'm not certain that's in the brief or not, Your Honor.
Okay. Well, so what was the argument you made in the brief? The argument was exigent circumstances
Exactly.
justify a search.
If it were, and maybe that was poor craftsmanship. So, in other words, exigent circumstances, if in fact it were deemed to be a search, I think that a review of the pleadings, and maybe the district court didn't touch upon that with regard to whether there was or there wasn't, but if it were, so if we start at that as a baseline.
Well, I'm just starting with the district court and the arguments you presented to us, and then the arguments you presented to us.
Right, I understand. And that being the case, I would argue that first, there are no exigent circumstances, and second, that we did not create.
Wait, you're going to argue that there wasn't an exigent?
Excuse me, I'm sorry, Your Honor. That there were exigent circumstances.
Okay, and what's your best case that anything remotely like this encounter was an exigent circumstance for the police?
Could you repeat that, Your Honor?
What is your best case that this encounter created an exigency that justified the entry into the home? What's your best case for that?
As far as my best case, Your Honor, obviously we relied upon various authority within the brief.
I don't see
Believe that the
any,
district-
it's not hot pursuit, right? What possible exigency? If they thought there was an exigency in the house, why would let him go in to get his keys at all?
Well, I think it goes to the points that you just made a moment ago. He was detained. We believe there is no fact dispute concerning the qualified immunity issue as far as what was he going to get, whether it was a phone.
Well,
whether
I'm
it
going to
was
interrupt you
keys.
again. He's detained.
Correct.
The exigency that allows a home entry.
The exigency would be, as we have argued, that if he's permitted to go in alone, that he could, as the case.
You didn't have to permit him to.
No, you're right. You're right. I mean,
How can we affirm the district court ruling in front of us that there was any exigency? I have a hard time getting past that.
Then
Without a case.
there are a number of cases that cite that officer safety or someone fleeing or someone destroying evidence is an exigent circumstance.
Okay, so he's detained though. So we know he's not fleeing and he's not destroying anything. They've got him in detention. And I don't remember any suggestion that their lives were in danger.
You're looking at it respectfully, Your Honor, from the standpoint that if we keep him outside, and the question is that if we allow him to go inside. And so the cases, as I see them, with regard to those in which exigent circumstances are not permitted because they find that the officer, said, hey, listen, you let us in or we're coming in. Things of that nature where the officer created it. The officers did not somehow cause this young man to say, I need to go get my keys or I need to go get my phone. So if they made him...
No, I thought that's exactly their allegation. They say the officer told him, go in the house and get your key.
I don't think that's what the record shows. I think they permitted him to do so, Your Honor.
Okay, so you think the record is undisputable that he asked to go back in?
I don't think there are any allegations to the contrary.
Okay.
I believe if we look at the appellant's own brief,
If you're wrong, if the police told him to go in and then escorted without consent, without hot pursuit, would you would agree there'd be no qualified immunity? If you're wrong, if they gave him the idea to go in and get his keys.
No, Your Honor, I would not. I would not.
What theory?
Under the theory that if they felt that they needed to, if they felt that we'll allow him to go get that, there's no proof that there was a search conducted. There was no proof they had any.
No, I'm asking you to assume we're going around and around. It's not them allowing anything. It's them saying, go in the house and we're coming with you. If those are the facts, is there any exigency?
I would say there would be. I would say there would. Now, I think maybe the better question there is, and then the question comes down to, did they create the exigency? Because, maybe we can't agree, but if someone goes into the house and that person is potentially dangerous, is that person dangerous regardless of whether he asked to go in the house or he's told to go in the house? I think the answer is that he would be dangerous no matter what, and thus the condition of the exigent circumstance of one of the frequently cited as officer safety, that is still there regardless. No matter whether he's told to go in or not told to go in.
Remind me, what did the district court say the exigency was, and what authority did the district court cite? Did they say there was an officer safety problem here? Did the district court?
I have that right here, Your Honor, if you'll give me 1 second.
Judge Biggers.
It notes that as to the Pollard's claim regarding the officer's brief entry into their home, the court finds the existence of exigent circumstances that shield the defendants from liability for this action. It then notes the standard under exigent circumstances, even a warrantless search does not violate the Fourth Amendment so long as the scope of the search is no broader than necessary to deal with the exigency. They cite Warden v. Haynes, 387 U.S. 294. Immediate safety risk to police officers and others are exigent circumstances which may excuse a warrantless entry into a residence, U.S. v. Jones.
So if we conclude there's clear error that there was any security risk to the officers, the only one that conceivably could have existed is that they tell them to go somewhere where they need to go to for their safety.
I would say yes. I mean, I go back to what I said a moment ago. I mean,
Sounds like then police can get into anyone's house without a warrant and without consent.
by telling someone to go get
Go on
something.
in, and therefore it's our safety, because you're in there and we need to go too. That sounds like a pretty big hole.
In this case, I would say first that there's been no proof put forth by the other side, and I think one of the panel just asked counsel, is there any proof whatsoever that they were looking for anything? And there's not. I can affirmatively state that the record is 100% void of any reference to the fact that when the one officer, recall, and I think this is further proof of the fact that the officers were acting in good faith for safety, they keep referencing 2 officers having gone in. But if the threshold to the house is here, one officer stepped in and he could see down the hallway. He stood right there to watch his fellow officer. The fellow officer walked with the young man. The proof is they were in the house for 1 minute or less. I believe the record is clear of that. So I don't think that it would be clearly established from a qualified immunity standard that the officers could not act as they did on the night in question. And so I would say, and you raised a great point, Your Honor, which I had written down on my notepad. What if, because it's clear, and I understand your point, that you're saying that, well, once you know, I don't think the officers needed a place to sit, but if he needed the key to get the tailgate down, okay, that's fine. They were going to sit on that. But what if he did say, I need my asthma medicine. I need my something. At that juncture, you know, if the officer says, well, go inside and get it. So now what are we analyzing? Are we analyzing the activity that's occurring outside that created the need to go in? And if we are, are there any cases where it shows that it's clearly established that an officer under such circumstances would not be entitled to qualified immunity?
Well, I think if the officer faces that hypothetical, which I think, but I may be wrong, is a disputed issue of fact. If the individual says, I need a sweater, then the officer says, do you consent for me to escort you so I can stay safe? And the fellow presumably would say, yes, I consent, because he asked for the permission.
Right.
But if he says, no, you can't come, then the officer says, well, I'm not going to let you in, because I can't go in that house without a warrant.
Right, and then we've created another problem, because then the contention will be that the officer wouldn't allow him to go get his medicine, or wouldn't allow him to go get whatever the item may be that we can think of. And so it's kind of darned if you do and darned if you don't under that situation. But I think from my review of the case law with regard to the officer-created situation, to me, those cases are situations where the genesis of the idea of going in the house, whether it's some sort of false threat that we're going to come anyway, whatever the case, whatever there may be present, that in those cases where the courts did not accept the exigent circumstance argument, the genesis of the action appeared to be with the officer. In this case, I would say that the officers didn't somehow cause them to say, hey, listen, I need my keys or my cell phone. I would note that in the record, if you look at the complaint says both. So I don't think it's a disputed fact as to what the item is. I don't think a plaintiff can create his own disputed fact with regard to alleging 2 different things. But a review of the complaint says, well, he either needed his cell phone or he needed his keys. The point is, the plaintiff said that. The plaintiff said, I need to go get, fill in the blank, keys, cell phone. The officers did not suddenly say, hey, why don't you go inside and get your cell phone? The genesis of the idea did not come from the officer. So once the young man said that, then I guess the officers had 2 choices. They were either going to allow him to go get the cell phone, and to be clear, the officers, and I don't want to get into disputed fact, but the reason the cell phone became an issue was because the young man was telling the officers that if they could just look at his phone, then he could show them that he was really out jogging that night, etc. So that's why the young man asked to go get the phone, according to the officers. But regardless, keys, phone, it was still the plaintiff himself who put into motion the need to go. And so at that juncture, I guess the officers had to decide, do we allow him to go in unescorted, or do we not allow him to go in? And I just don't think that it's clearly established that allowing him to go at that juncture and escorting him with something extremely brief in time, and I would even say brief in time and scope for 2 reasons. One, it was less than a minute or less, according to the record. 2, there's no proof by Isaac Pollard, who the officer was standing right there with the whole time, that he looked at anything, looked around his room, tried to find anything. And also there's no testimony that the officer who stayed in the entryway attempted to look around, do anything, or do anything other than make sure that his fellow officer was safe. So I would think that under those circumstances, with regard to the reason for the entry, that it was permissible, and I would say that the case law would either support the entry, existing case law would either support the entry, or I would say that it's not clearly established that they could not go in such that they are still entitled. I guess, we always get back to the basic question in qualified immunity. Would no other reasonable officer have thought that it was okay for one officer to stand guard and the other to escort to allow the young man to go get what he said he needed? That's how I think that it's framed from this scenario, and why I think that the district court got it right in finding the exigent circumstances. And again, I note that the initial point that triggered the entry into the home did not come from the officers.
You're very emphatic about that. I thought that was a disputed issue of fact. I still have a very difficult time, unless you can give me a case, seeing exigency here, even when the occupant initiates the request. I would think with any factual development, your clients might prevail because it would be implied consent. I really need to go in quickly, and at that point the police say, okay, can we come? Implied consent, he's seeking it. Or they say, oh no, I need to get it, but I can't have you. At which point, there's no exigency, they just don't let him go. They keep him detained on whatever suspicion they had.
So, Your Honor, just to be clear, are you saying that you believe any time that if the facts show in this case that the record shows that it was the plaintiff that asked, initiated the item that's inside the house? I think that's clear. I would say that the record
I don't usually answer questions from attorneys, but I'm happy to tell you that I think even if that's the fact pattern, it's not an exigency that allows entry in a home. There's no exigency. I think it's probably an implied consent case. That's not what Judge Biggers ruled here.
So
that's just.
Then how do you balance that with?
Well, no more questions here. My colleagues may have questions, but I have more. I thought you did argue below, but without legal citation, that there wasn't a search, that these officers, rightly or wrongly, reasonably believed they weren't doing a search. Now, there was no citation to the Jones decision, but it comes after Payton. And so, do you have any law that supports the notion that Jones sort of revived sort of the trespass theory instead of the cat's reasonable expectation? And so now we're looking at a textualist. Was there a search? No, they weren't looking for anything, if we allow subjective inquiry. Was there a seizure? Undisputed, no seizure. Hence, no search. Would you love to resuscitate that argument, or are you really just defending what the district court did?
No, I would say, Your Honors, I did from the outset that we would say that there was no search from a textbook definition of that, and would note that. And I must confess, be candid here, when you began preparing for things like this, that you began looking and you began thinking of different things. And I don't mean that from the standpoint of raising arguments that weren't raised in the lower court. But the Jones case, in which, if I recall correctly,
was the GPS installed, and they actually do find a search, because that's a technical trespass. So
right.
It have to be this footnote dicta. What does it mean? Does it create some uncertainty in the law? Because the court found a search there, just as they'd found
and add to that, does it make any difference that that case did not involve a house or a home?
As far as the car that they put the GPS on, Your Honor, is that what you mean?
Right.
Well, I think if we're talking purely about whether there was or was not a search, I don't think it would affect anything. And I think that maybe there are simply some situations.
Let me ask you one more question.
Yes, sir.
This is the last one.
That's all right.
Are you relying on the argument that the Fourth Amendment only protects against searches In other words, if someone goes into a house and he's not searching, that's not protected. That
Your Honor.
does not protect the owner.
That is precisely
Owners of the
the
house,
issue that I gave great thought to before
against
coming here today. And I think my answer is,
Against
Hold on, Counsel, let him.
oh, I'm sorry.
against an intrusion.
I believe that the Fourth Amendment would not. In other words, to be clear, I believe that if an officer, for whatever reason, walked into my home or your home without a warrant, without any basis whatsoever. Now, obviously, we've got to come up with a fact pattern if we're going to, do that here. He's not conducting a search, and he's not attempting to effectuate arrest. I believe, and I think that's what this footnote was maybe trying to say, that not all claims give rise to a constitutional violation, and that it might be no different than me coming in your homes or an intruder coming in, and that would be a state law trespass. And I say that only from the standpoint of that the Fourth Amendment protects against unreasonable search and seizure. So if there is no search and there is no seizure, then maybe it arises under some other amendment that I can't think of right here off the top of my head, but I would think that would be some sort of state law claim, absent the facts to support that there was a search or a seizure.
That argument would have really big consequences in this criminal justice system. Police can walk in.
I understand.
What happens if they're in there and they're not going to seize and they're not going to search, but then in plain view they see contraband?
Then I would think that it would
Can you
absolutely.
take that or not?
I would think under that circumstance, and criminal law is not my forte, but that evidence would not be admissible because there was no valid basis to enter the home. So that type of evidence would have been gathered based upon an impermissible entry. Because I'm not arguing that the entry is permissible. I'm simply saying that if that were to happen, and it would have to, all parties would obviously have to get in the posture of agreeing that there was no search, there was no seizure. It's a great question, but I don't think that evidence would be admissible because it was not taken pursuant to a lawful entry into a home.
Under the Fourth Amendment.
Yes, sir. Thank you.
All right, thank you, sir. Back to you, Mr. Priest.
Your Honors, if I may just put a fine point on that last discussion. In the court in Payton said that language, the language of the Fourth Amendment, unequivocally establishes the proposition that at the very core of the Fourth Amendment stands the right of a man to retreat into his own home and to be free from unreasonable government intrusion. It doesn't say search. And Your Honor, frankly, and I said this earlier, the footnote in the Johns case is, I don't know. Yes, Your Honor, I don't know how to read that.
The original public meaning, clearly home is most sacrosanct. Cats, expectation of privacy, one does in a home. Even trespass theory, they physically trespassed. But footnote 5 is a strange thing.
Yes, Your Honor. I don't know how to reconcile that footnote with Payton or Katz or the other case.
It wasn't the basis for the district court's ruling. The ruling said exigency. Do you want to speak to that? And particularly his repeated statement that it was Mr. Pollard's request.
Your Honor, it's in the record. It is pointed out in the brief by a citation to the part of the record. Isaac Pollard testified in his deposition that the deputies wanted to sit on the tailgate of his truck. He's like, I can't unlock it. I don't have my keys. Go get your keys. That's the facts as we set them forth, and as I believe are in the record.
He wanted to sit on the tailgate of the truck.
Yes.
He had to have a key for that?
Apparently, Your Honor. I'm not even sure what type of vehicle it was. I don't know if lowering the tailgate would have set off an alarm or something. But regarding a disputed issue of fact, I don't,
If he'd said, if they were right, and there is no dispute of fact, if he'd said, I need to go inside to get whatever, would your case be different if the police didn't get a warrant?
I think I think so, and I think it goes back to what Your Honor said earlier about it being an implied consent case at that point. If he had said, I need to go get my phone, and they're like, okay, let's go get it. That seems to be an issue of implied consent at that point. And I see that as different from them giving him instruction to go inside when it was unnecessary and because they had him detained.
You've got 1:30, and I asked too many questions. What else were you going to say in response to his arguments?
Your Honor, I was just going to point out that in the district court's ruling, it mentions the presence of exigencies, and it quotes language from a case from this court saying immediate safety risks to police officers and others are exigent circumstances which may excuse a warrantless entry into a residence. The district court did not articulate how there was any sort of safety risk present. Judge Biggers simply mentions that in general without any type of articulation as to why the officers should have felt threatened or felt that Isaac was going to engage in any other kind of misconduct inside.
Okay.
Yes, Your Honor. If there's...
Is your primary argument that there are fact issues, or is your primary argument, a legal one?
Your Honor, my primary argument is that there are fact issues that would require reversal of the judgment of the district court and remand.
Okay, and just say succinctly for me, what are the disputed facts that you argue need to be unraveled?
Your Honor, as to the predicate for detaining Isaac, the facts are in dispute as to, well, there is a fact dispute regarding his conduct that night as observed by witnesses and as he explained it. Of course, there's the factual dispute regarding the warrantless entry that we've discussed on and on. As to one of our claims, the excessive force claim, which is based on a psychological injury, we would say that Judge Biggers found that there was no evidence to support that when in the record we did have clear evidence that that Isaac suffers from PTSD as a result of this interaction.
Okay. All right.
Thank you.
Okay, thank you. Thank you to both sides for your briefing and argument, and especially responding to the questions that the court has. This completes the arguments in cases for this front end of the sitting, the 2 days. And so with that, the panel will be reconstituted tomorrow and resume at 9 a.m. For these, we now stand in recess.
But we'll miss you very much.
Thanks a bunch.